I got so much money.
Are you ready, kids?
Aye, aye, Captain!
I can't hear you.
Aye, aye, Captain!
Oh!
Good night everyone, ladies and gentlemen. My name is Rahmat Anugrah from Sharia Economic Law. Today I would like to present a legal topic that is highly relevant to economic transactions in Indonesia, especially in the context of contracts and agreements. The title of this presentation is Legal Consequence of Default from the Perspective of Islamic Economic Law and the Indonesian Civil Code. This presentation is based on an academic article written by Muhammad Fahmi Hibatullah, published in Good Journal of Sharia Economic Law Studies in 2024. The discussion focused on how Indonesian law regulates default of or breach of contract and how this concept is viewed differently under Islamic economic law and the Indonesia Civil Code. We move the background of the study. Indonesia recognizes two main legal frameworks in resolving contractual disputes. One, the Indonesian Civil Code, inherited from Dutch law. Two, the compilation of Sharia economic law, applied mainly in Islamic economic transactions. In practice, non-Muslim communities generally rely on the Civil Code, while Muslim communities may choose either the Civil Code or Sharia economic law. This dual legal system often raises questions regarding default and its legal consequence. 2. Definition of agreement and contract. An agreement or contract is a legal relationship between two parties, one debtor who has obligation, two creditor who has rights. Under the Indonesian Civil Code, an agreement is defined as an act whereby one or more persons bind themselves to one or more other person. In Islamic law, an agreement is known as akad, which must fulfill specific pillars and conditions, including parties of the contract, 2. Mutual consent, ijab and kabul, 3. Object of the contract, 4. Lawful purpose according to Sharia. The main point 3. Validity requirement of an agreement. According to Article 1320 of the Civil Code, a valid agreement must include 1. Mutual consent, 2. Legal capacity, 3. A specific object, 4. A lawful cause. One key difference highlighted in the article is legal capacity. Civil Code minimum age is 21 years. Sharia economic law minimum age is 18 years. This difference shows how Islamic law adapts to social and moral maturity rather than formal age limits alone. The main point 4. Concept of default. Default refers to a failure to fulfill contractual obligation. In general, default occurs when a debtor 1. Does not perform the promised obligation, 2. Perform it improperly, 3. Performs it late, 4. thus something prohibited by the agreement. Both legal systems recognize this form, but they differ in terminology and consequence. The main point 5 default under the Indonesian Civil Code. Under the Civil Code, default results in several legal consequences, including compensation, which consists of costs, losses, interest, contract cancellation based on a court decision. 3. Transfer of risks, especially in contracts involving goods. Before compensation can be claimed, the creditor must be issued a formal warning. The main point 6 is default under Islamic economic law. In Islamic economic law, default is referred to as ingkar janji. The consequence focus more on 1. Fair compensation based on actual loss. 2. Justice and moral responsibility rather than punishment. 3. Avoidance of elements prohibited in Islam, such as riba or interest. 2. Gharar or uncertainty. 3. Harm or dahar. The main point 7 and the last is dispute resolution methods. Both systems encourage dispute resolution through 1. Mediation or family-based settlement. 2. Court litigation. However, Islamic economic law also emphasizes 1. Peaceful settlement. 2. Arbitration as alternatives to court proceedings. This method aims to preserve harmony and fairness between the parties. Right. To conclude, default or breach of contract is a legal event that occurs when one party fails to fulfill agreed obligation. Both the Indonesian Civil Code and Islamic economic law recognize default, but they differ in 1. Legal terminology. 2. Sanctions imposed. 3. Philosophical foundation. While the Civil Code emphasizes legal certainty and compensation, including interest, priorities, justice, ethical conduct, and Sharia principle. Therefore, the legal system can serve as a basis for resolving dispute in Indonesia, depending on the parties involved and the nature of the agreement. Thank you very much for your attention. I hope this presentation has provided a clear understanding of the both legal perspective. Thank you.
And with that, the 2025 season comes to an end. Good night.